Good morning, everybody. Josh Denbo here, consumer protection attorney. Now I practice law in New Jersey only. And most of my videos have to do with mortgage servicing and, fraud by predatory lenders and that kind of thing nationally, or at least not specific to New Jersey. This one is just for New Jersey. So I'm sorry for everyone outside of the state. And the reason it can only be for New Jersey is New Jersey has a specific way of dealing with foreclosure filings and foreclosure in general that's not matched by any other state. It's just how New Jersey does things, and that's my expertise. Let me give you a couple of tips. When you're running into trouble and you're looking for help, do not do business with companies that are outside New Jersey. Period. Flat. Don't do it. Don't do it. They're going to push you into a bankruptcy filing. They're going to push you into a loss mitigation application that's probably nonsense. They don't care. They don't do a good job. They don't really fight. They may file an answer to the foreclosure complaint if you're lucky, but they won't actually put up any defenses, and they won't care if the mortgage servicer in the past violated your rights, because that's not their business model. Their business model is volume on loss mitigation. They will file papers for you, and that's it. And it's not a good fit. The other thing to look out for is a law firm that does bankruptcy and mainly does bankruptcy. So the old adage, if the only tool in your toolbox is a hammer, every problem looks like a nail. If these bankruptcy attorneys are reaching out to you and you say, well, I'm in foreclosure and this, oh, you need a Chapter 13 bankruptcy. Well, you might. It's possible. But not every single person who calls the firm needs a Chapter 13 bankruptcy. It's a tool, not an end. I get so annoyed at bankruptcy counsel that just push people into bankruptcy filings, because it's important and useful sometimes. And I work with a select few bankruptcy attorneys who I know don't try to sell people something they don't need and are good at their jobs. And they push the bankruptcy filing when it's necessary, when they take people into bankruptcy. And it makes sense sometimes, not every time. The difference is really simple and subtle. Not that subtle, simple. If you have been harmed by a mortgage servicer, lender, anybody else, and you have a claim, bankruptcy is not the best place to pursue it 9 times out of 10. I've pursued them in the bankruptcy court, sure. 9 times out of 10, you just sue the bastards. You don't wait to file bankruptcy. You just you stay in state court, or you file in federal court and you bring your claim and you litigate it. And you make the people who harmed my client pay their counsel fees, pay their damages. There's no need to file bankruptcy most of the time if you've been harmed by a mortgage servicer. And harm by the mortgage servicer can be improperly calculating escrows. Oh, that happens all the time. Losing loss mitigation paperwork by the servicer all the time. A mortgage servicer in the middle of loss mitigation, a modification application, transfers servicers, and the new servicer says, I don't know what you're talking about. You have to start over again. No, you don't. No, you don't. You don't. You have one contract. It's for your mortgage loan. If the mortgage servicing changes, then the new servicer has to come in and play by the rules set up by the old servicer. The good and the bad for them. That's how it is. That's how it is. So when you're looking for the attorney, please don't go to a bankruptcy counsel just because they tell you that bankruptcy is the answer. It's probably not. And definitely do not work with an out-of-state company. Don't do it. You're looking for trouble. All right. Josh out.